All right, everyone, we're going to go ahead and get started this morning. Good morning. My name is Margaret Fieldbinder, and I am one of the event coordinators at Diversified Insurance Solutions. I would like to welcome you all this morning and thank you for joining today's webinar, Employment Practices Liability, What You Need to Know. Before I turn over the mic to our speaker, Erin Kilmer from Philadelphia Insurance Companies, I wanted to go over a few items. First, everyone is currently muted in listen-only mode for this webinar. This will help keep the webinar moving along and keep us to our designated end time of 9:15. If you have any questions during the webinar, feel free to type it in the chat box along the right-hand side of the screen. We've reserved time at the end of the presentation to answer any questions you may have. We will try our best to get through them all, but if for some reason we're unable to get to your question, we will send it to you within the next few days along with a recording of this webinar as well as a copy of the presentation. Now I'd like to turn over today's presentation to Erin Kilmer from Philadelphia Insurance. Erin is an underwriter for Philadelphia, covering the North Central and Ohio Valley regions. She has over 10+ years of experience in the insurance industry and earned her RPLU designation in 2013. Since then, her focus has been on directors and officers insurance and employment practices liability insurance. With that being said, please take it away, Erin.
Thank you, Margaret, and thank you everyone for attending. I just want to go over the basics of EPLI insurance and try to answer any questions that you may have. So first off, who needs EPLI? I would say any company that has employees or even volunteers should consider this coverage. Coverage is going to protect you against allegations of discrimination, harassment, wrongful termination. And even if you're a nonprofit and you only have volunteers, your selection of who you choose to be volunteers could also be construed as discrimination. Some industries that commonly have EPLI and that we insure a lot of, nonprofits. Nonprofits have volunteers, full-time employees, part-time employees. They often have a third-party exposure, which is covered in most policies. Third party means anyone who feels discriminated against or harassed and is not your employee. So it could be clients, customers, people who applied for a job but didn't get it. Restaurants, we have lots of restaurants, and this is a class that often seeks out EPLI insurance for their full-time and part-time. And they also have a large third-party exposure. Consultants, they have lots of independent contractors, so they may not be classified as full-time or part-time employees. However, depending on which insurance policy you buy, the definition of employee may or may not include independent contractors. Phillies does, so that's something to look for if you are a consultant or if you hire independent contractors. Retail industries, they have a lot of seasonal employees. Think around the holidays. That's going to bump up your employee count. So all those people could potentially file claims. Manufacturers is another one. We see lots of manufacturers. They have lots of employees also. So the main entity that is enforcing employment laws is the EEOC. The EEOC is a federal organization that is responsible for enforcing federal laws that make it illegal to discriminate against a job applicant or an employee because of a person's race, color, religion, sex, pregnancy, national origin, age, being 40 or older, disability, or genetic information. So that is a huge group of protected people. It's also illegal to discriminate against someone because that person complained about discrimination. So even if an employer does everything right, you have all the procedures in place, there is still a good chance that someone could determine that they might be discriminated against because there is such a large class of people that are protected. So the EEOC filed almost 90,000 charges in 2015. The biggest counts were race, retaliation, and discrimination. So the retaliation part of this is For example, what I said earlier, complaining about discrimination. So if a person complains about discrimination in the workplace and then is terminated, that's a retaliation claim, and those happen frequently. So if there is an EEOC case, the average mediation duration is 84 days. So it can take 84 days on average for the EEOC, the employee, and the employer to come to an agreement. So that could be settlement, reinstatement of the job, whatever the employee is demanding. Before that even happens, the investigation leading up to this can be a year or more. The EEOC has so many cases that they're very slow moving. So this can be very time consuming for employers. So third party, like I said, is anyone who's not an employee. That could be failure to employ, discrimination, sexual harassment, or violation of civil rights. And one thing that I found on the EEOC website, they are advertising this on their website and trying to recruit people for third-party discrimination to join their class action claims. So for example, there is a class action against Texas Roadhouse, which is a restaurant, for failure to hire due to age. So the allegation there was for front of the house positions, people over the age of 40 were not being hired. And the EEOC is advertising this on their website. They want people to join in on this lawsuit. The other one was Bass Pro Shops. The class action allegation was that they were not hiring people of a certain race. And then another one was Mavis Discount Tire, that they did not hire women. So those are all third-party claims. Those people were not employees, but they were discriminated against because they felt like they were not offered jobs at the same rate as the other classes. So the most often types of claims that come up on EPLI policies involve hiring or failure to hire, like we've talked about, firing decisions, which is wrongful termination, failure to promote. That can be, say you have two workers with similar qualifications and one gets promoted and one doesn't. That can be a claim if one of those people is a protected class. So one might be a woman of color who didn't get promoted and the young white male did. That could be a potential claim. Failure to accommodate. Failure to accommodate disabilities can be a common claim. If a person has an inability or they have an injury, say they work in a warehouse and have an injury, that employer should accommodate that injury and give them a different task to accommodate their injury. So maybe they can't lift a certain weight, but hopefully the employer would be able to accommodate the disability and get them into maybe an office position or an administrative position. Other types of claims involve downsizing. Sometimes employers can't help this. Funding is not there, sales may not be there. So one of the first ways a company is going to try to cut costs can be downsizing. So that can bring up some employment practices claims also. Equal pay. Equal pay has been in the news a lot. That's equal pay for the same job. So women and men should be paid the same for the same job. And if women are not, that could be another claim. They may demand more wages or damages in order to meet that wage gap. Another one that comes up frequently that is actually happening more often are the whistleblower retaliation claims. So that may not even be anyone in any of those protected classes that I mentioned. The whistleblower claim can be, say a person in accounting thinks that the accounting practices that their employer is doing are not up to par. And that person brings it to the CEO's attention somehow. So now there's an audit. There's an audit of the accounting practices. So if that person that brought this matter to the attention of the company gets fired, that can be a whistleblower retaliation claim. That person may not have been discriminated against. They may not be in any of those protected classes, but the timing of that termination after bringing an issue to the attention of the company those are big claims. Does anybody have any questions so far? Okay. So the next I was going to go through some examples of claims. An age discrimination claim, like I said in the beginning, anybody who's over 40 is protected by this. An age discrimination lawsuit was brought about by a highly paid 62-year-old sales rep who was employed by the insured. So he was terminated for not meeting his sales quotas, and the settlement was ultimately $540,000. So these highly paid individuals tend to correspond with high payouts on claims. So in this case, the insured didn't have proper documentation showing that the plaintiff was a poor performer. So as an employer, it's very important to have lots of documentation in place. So like on our employment practices application, we ask, do you have an employment application for every person? Do you have a handbook that is distributed to everybody? Do you have annual reviews? All of that helps documentation if a claim does arise. And that's going to help your claims handler defend you. Another one is disability discrimination. This can happen a lot when there are medical leaves involved. So this employee went out on medical leave for an illness. When he came back to work, his position had been filled by someone else, and his job was no longer available. So he filed suit for lost wages, emotional distress, and violation of the disability discrimination statutes. And that claim paid more than $100,000. Another one I have is pregnancy discrimination. This was a recent claim for Philly, which is on one of our policyholders. The claimant was a director of HR, and she was terminated 15 days after she told her employer she was pregnant. The insured stated that she missed mandatory meetings and that she was falling behind on her job duties. However, this wasn't documented, and with the timing, 15 days after she was notified of her employer that she was pregnant, this timing was terrible. So this claim settled for over $25,000. Also in this case, the HR director, she made allegations that not only was she terminated after she was notified of her pregnancy, but she claimed that that insured also posted jobs for other people who became pregnant and didn't promote people who were pregnant. So that's a little bit of the whistleblower thing that I mentioned earlier too. Wage and hour claims are very popular concern for a lot of insureds. Wage and hour claims can be brought by an individual or as a class action. So either an individual can claim that they are not coded appropriately, so they may be a full-time employee that was coded as an independent contractor and paid differently, or maybe they were a non-exempt employee that was coded the wrong way and not paid overtime. Or it could be a class action lawsuit. This happens in like restaurants and franchises a lot, where there might be systematic pay disputes for the employers. So the one class action lawsuit was seeking overtime pay at a nonprofit community mental health center. So these people were working overtime but did not get paid appropriately for it. And this insured had a $50,000 retention, which they paid themselves, and then the insurer paid another $26,000 on top of that to settle this claim. So something with these mental health centers or hospitals or hotels, anything that's open overnight, that can be a higher risk for these wage and hour claims because people work 24 hours a day. So how do you decide when the week starts? Does it start Sunday? Does it start Monday? And where do you count the 40 hours? Do you count it from Sunday through Saturday? Do you count it Monday through Sunday? There's a lot of questions when they're working 24 hours. Do the people who get paid, do people who work overnight get paid more than the people who work during the day? All those questions make these companies that are open 24 hours a day at a higher risk for these wage and hour claims. Another wage and hour claim example, this one was also a class action. At Morgan Stanley, which is a brokerage firm, employees alleged that they were denied overtime pay. So 3 people filed a claim on behalf of over 800 employees in the class action, and that was a $2.4 million settlement. So luckily that wasn't a Philly policy, but that one was pretty severe. So when you're looking for EPLI coverage, different carriers offer different limits. We offer limits of $500,000 and up. Something also to look for is whether defense costs are in addition to the limit or within it. If defense costs are in addition to the limit, that means that, say your deck page says you have a $500,000 EPLI limit. If defense is outside, anything that your insurer pays for attorney's fees in defending you in that allegation does not erode your $500,000. So even after you pay your attorneys and all the fees, you will still have $500,000 to pay a settlement if it comes to that. Automatic third-party coverage, Philly's policy includes that automatically. That's what I said before. Third parties are people who are not your employees. They may be volunteers, and maybe clients, and maybe people who were not hired. Choice of counsel. Some policies offer the option of choice of counsel. Ours does. So if you have a policy with choice of counsel, you can use the attorney that you want. So if you have your favorite employment law attorney and you want to use them, get a policy that has choice of counsel. Otherwise, you will use the panel counsel that the insurer chooses. You want to look at the definition of employee. Depending on your industry, does it include volunteers? Does it include independent contractors? Does the definition include seasonal employees? You want to make sure that it's a broad definition so that you have more protection there. Wage and hour coverage, like I talked about. Most often, wage and hour coverage is offered as a defense-only limit. So a wage and hour coverage would be, for example, $100,000 additional money for the defense of wage and hour claims. Most often, there is not a settlement provision for wage and hour claims. And then this Wilson-Elser hotline, that's something that's unique to Philly. We offer to our policyholders access to an employment law firm. So if you are a Philly policyholder, you will have their number. And if you have a question about employment practices, then you have to consider a layoff or a downsizing, call Wilson-Elser, and they provide 2 hours of free consulting to help you through that, to help you make the best decisions on how to handle that issue. Or say you have an employee who is troublesome, they're a poor performer, and they're making allegations or threatening lawsuits. You would call Wilson-Elser and they would help you handle that situation. So that's what Philly has specifically. I think other carriers also have, they may have similar things, I'm not really sure. But you might want to ask about their risk management help. Because as an insured, you probably don't have an employment lawyer on staff. So that's why these kind of hotlines are very helpful. So I kind of went through that quickly. Does anybody have any questions about anything I said?
Could you give examples of claims for downsizing?
Sure. That could also be, that could potentially be a class action as well. So if, for nonprofits, a lot of times you'll see that they have grants, federal government grants for specific programs. So I've seen where they may lose the grant for whatever reason. So if they lose a grant for a program, they have to eliminate that program. So if they don't have another program to replace those employees on, all those employees that lose their jobs because the grant is gone could get together and file a downsizing claim because they were wrongfully terminated. You know, they didn't do anything wrong. There's just no money to fund that program anymore.
In this specific case, we recently reduced staff due to low sales. We downsized individuals across the board from office to production based on the workload. Do you see those types of claims often?
We do see those. It depends on the wages of the people that were downsized on what the demand and the settlement might be, but hopefully that that insured or that company, hopefully they have a lot of documentation that what happened with the funding. If they offered replacement employment, did they help those downsized employees find other employment? All of those things can help you defend yourself if a claim is filed against you.
Excellent. Thank you, Erin. Just going to leave the line open. I believe you're at your end of your presentation, so we'll give everybody a couple of minutes. Feel free to type your questions into the chat box. Otherwise, if you are pressed for time, please feel free to log out.
Well, thank you everyone for listening.
Yes, thank you. On behalf of Diversified Insurance, I'd like to thank you again for joining us today. We hope you found today's information to be of value to you. Just a reminder that we'll be sending a recording of this webinar as well as the questions that were asked during the presentation and a copy of the presentation itself to you. A recording will also be available on the Diversified website under the Library tab. Thank you for joining us today and have a great rest of your day.
Thank you.